Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We've had a lot going on in the Justin Baldoni versus Blake Lively case today with the new allegations that Blake Lively had tried to extort Taylor Swift and also witness tampered by trying to get Taylor Swift to delete their text messages. Bryan Freedman wrote about this in a letter to the judge because Blake Lively and Ryan Reynolds had filed a motion to intervene and try to quash a subpoena that the Wayfarer parties had served upon Venable, the firm that represents Taylor Swift. Friedman argues that this should not be quashed and stated that Venable is working with Justin Baldoni's team in good faith. Responding to the allegations of alleged extortion, Mike Gottlieb, the attorney for Blake Lively, had given a statement to TMZ, basically stating these were totally false allegations and that it was cowardly of them to attribute it to an anonymous source, which, when you think about it, is kind of hilarious, given the backdoor methods that they've used to obtain evidence for their case. So now when I look at all this in the context of the bigger picture, I'm thinking I've heard smarter things come out of a vegetable, not even a cooked one. Anyways, we're going to take a look at this motion to strike Bryan Freedman's letter, which was just filed with the courts by Blake Lively's attorneys. Dear Judge Lyman, on behalf of our client Blake Lively, we respectfully move to strike the letter signed by Mr. Bryan Freedman and filed earlier today. That letter, which was not filed with any evidentiary support of any kind, much less anything under oath, falsely accuses Ms. Lively and her counsel of engaging in witness tampering and evidence spoliation based on an undisclosed anonymous source. Ms. Lively requests that the court strike the Freedman letter pursuant to its inherent power to control and strike material from its docket that is abusive or otherwise improper under the circumstances. It should be unnecessary to respond to anonymously sourced, baseless allegations recklessly leveled without any supporting evidence. It is worth stating for the record, however, that each of the allegations in the Freedman letter is unequivocally and demonstrably false. As a legal matter, the Freedman letter is improper. It does not seek any form of relief, is irrelevant to any motion currently pending before the court. Well, that's just not true. What? I mean, they wrote a letter to the judge in this case talking about their motion to intervene and quash, and he responded. How is that? Whatever. Is irrelevant to any motion currently pending before the court and serves no legitimate purpose. It is not useful to the court in any respect. Ms. Lively filed a letter to which the Freedman letter purports to respond as a courtesy to inform the court about motion to quash proceedings that Venable commenced in another federal court and to preserve her own right to object to the third-party subpoena. But she did not ask the court to take any action, and her letter did not merit or warrant any response from Mr. Freedman, let alone one that purports to manufacture a conspiracy theory in order to obtain communications from opposing counsel via a third party. The apparent intent of the Freedman letter is to launder scandalous and defamatory allegations about Ms. Lively and opposing counsel into the press by abusing the court's docket and avoiding the order requiring attorneys in this case comply with Rule 3.6 of the New York Rules of Professional Conduct. Within minutes of the Freedman letter appearing on the court's docket, at 1:50 p.m., media outlets began publishing stories concerning the Freedman letter, including one that posted a 40-plus paragraph article at 1:55 p.m. that asserted as a fact that Ms. Lively threatened to expose Taylor Swift's private texts unless she publicly sided with her in the Justin Baldoni feud. And that's where they're citing the Daily Mail. Have you guys ever read an article in one of these publications? A good bit of it's copy-pasted. They just paste a recap of stuff that's already happened. So let's not pretend that's that shocking. Obviously, people were waiting to hear more about the Taylor Swift stuff, since this whole motion to quash thing just started the night before last. During a hearing on February 3rd, this court explained to the parties that it would intervene if it turns out that this ends up being litigated in the press in a way that would prejudice the opportunity of the parties to a fair trial. The court should promptly strike the Freedman letter from the docket to avoid exactly the result it presaged at that initial hearing. Whether to grant or deny a motion to strike is vested in the trial court's sound discretion. Ms. Lively respectfully requests that the court exercise its inherent authority to control its own docket and strike the Freedman letter as unnecessary, improper, and abusive. Ms. Lively reserves the right to move for sanctions consistent with Rule 11 of the FRCP in connection with the Freedman letter at an appropriate time. Well, there you have it. We're going to have to wait and see what the judge says about that letter, but this is all out there now, so that's all I got for you at the moment. I'll see you all soon.